And now I have the pleasure of introducing today's webcast, Administering the Modern Law Office, How You Help Create Success. First, I'd like to thank our sponsor, LawPay, the best in payment processing exclusively for attorneys. And now our presenter for today is Claude Duclos, Director of Education, Ethics, and State Compliance, LawPay. Claude is an attorney licensed in Texas, Colorado, and California who speaks regularly on legal ethics, law office management, and trial-related topics. In 2011, he won the highest statewide award from the State Bar of Texas for lifetime contribution to CLE and has been invited to speak in more than 250 programs since January 1st, 2009, and serving as course director of numerous institutes and advanced courses. Claude has a long legacy of bar service, including being president of the Austin Bar Association and serving as chair of almost every major bar-related entity, as well as the Texas Bar Foundation. And without further ado, Claude, the floor is yours.
Thank you very much, Regina. And folks, I hope you will enjoy this. There's a lot we're going to cover. You're going to think, a lot of you, that I talk too fast, and I am going to talk too fast because we have a lot of stuff to cover, and I really tried to make it very, very relevant to what you do every single day as helping create success for law firms. There's so much that I have learned. And for example, I have dumped all the slides out of here dealing with conflicts of interest and everything. What really is more important to you are office operations. So let's talk about what we're going to cover today. Now, here's the other thing I'm going to tell you. If I talk about a contract, I have a million contracts. At the end, you'll see my email, just simply where I receive email from the seminars are claude@lawpay.com. Just simply Claude, C-L-A-U-D-E, @lawpay.com. And that slide will appear at the end. Or if you have a question that we don't get to, I'll try to leave a little time for questions, but I'm happy if you don't have time to have your question, just email it to me, and if you want me to call you just to chat about it, I am more than happy to do that. I gave 2 days ago, I gave a nationwide seminar about how to run an IOTA account, a law office trust account, and we had 973 people, so I couldn't get to everybody's questions, but I stayed till 8 o'clock at night to make sure I responded to every email, and it's my pleasure to do that. All right, so the client relations, that's really important to the operation of a law office. Documenting the representation that you make with a client. Running the office, the day-to-day operations, how you bill people, you know, what are smart billing, what's stupid billing, how do you get that money in the door? Because, you know, it's a stressful occupation, and if you're not going to get your bills out and you're not going to get paid, I'd rather be out just walking around the lake or, you know, taking a bike ride or something like that, because we're doing this because it's our profession. So let's get the work out, but let's get the money in the door for doing that work. And then finally, cybersecurity. I have a number of slides to show you, but there's 3 things you'll see that I really want you to do with every single computer in there and to change your ways and make sure that this is done. But let's get started. The top 5 law office problems are communicating. The number 1 grievance against lawyers, not only in the United States, but in Canada, in North America, is my lawyer won't call me back. My lawyer won't answer my question. My lawyer won't answer my emails. I can't get my lawyer to do it. And that's because we make mistakes as lawyers taking that client, and we don't know maybe half the time how to do the work that we promise we can do. We've lost interest in it, and so we make up excuses not to call that lawyer back. And then second is neglect, but that usually results from number 1. If you don't want to talk to that client, you're not going to do that client's work. And then simply mishandling the attorney-client relationship, not having the right contracts, not having the right disclosures, not having the right expectations between the firm and the client. And remember, that goes both ways. You should have reasonable expectations of what that client was going to do when you do the work, and that client should have reasonable expectations of the limitations and the strengths of what you are going to do. And then not checking with conflicts. And then finally, I still talk about whose file is it. You know, if you separate separate from the client who owns that file, and it's actually the client does. All right, then attorney's fees, the stupid way that we get in trouble with overcharging or spending too much or the way we write up our bills. We think that's just a menial little task, but that is the secret of success, making that bill so somebody wants to pay it and getting it out on time. That is the absolute 55% of getting paid is getting that bill out on time. And then cybersecurity, which is a growing problem. I'll bet everybody listening to this has some friends who have said they stole my identity, or somebody hacked into my account, or somebody stole this, or I'm getting these, or even got hit by the ransomware like I did. So let's go on and talk about it. The most important thing, I always tell young lawyers when I get invited to talk to the newly licensed lawyers, and I say, look, there's one central word to the entire practice of law: communication. Communication, communication, communication. We are in the problem-solving business. Yes, lawyers come out of school and you learn terrific tasks because you know how to do this. But what are we first and foremost? We're an office of problem solvers, and we rarely get to see clients for the first time if in a good mood and happy, because as in our problem-solving mode, there's really, I'd say, only about 20% or less of lawyers get to deal with happy things all the time. Most of us see people in stress. When we first see a client, it might represent an betrayal of the most beloved person in their life. It might be an unexpected event, a death in the family, a serious injury, a traffic, huge things that's left someone with injury. So we have to work that in and know how to interview people in that light. So the potential client, remember, you can't succeed with bad clients. It's simply that. It's true. So intake is our first chance as a firm to bond and assess that client history. And what we have to do, I will tell you, and if you've heard me speak before, listen to the client respectfully and intensely. Pay full attention. Don't take other things. A lot of you, I'm sure, do the initial interview for the firm or for the attorneys for whom you work. So listen, get all that stuff out, because you might know in the first 5 minutes what needs to be done for that client. But that client might have unreasonable expectations when it comes down to it. So unless you listen all the way through, you're not going to be able to bind with that client. And that client won't have any confidence in the advice you tell them, because you didn't even bother to listen to their story all the way through. And then here's a good thing. You check early. You ask good questions. When I say that, good lawyers and older lawyers know that you check in the first 5 minutes. By the way, before we get started, or before you tell me your story, who else will this involve? Does this involve some party on the other side? What is the name of that company? What is the name of that firm? Because I know young lawyers say, I don't have any business. I certainly don't have any conflicts. But when you have somebody like me who's been licensed now, as of last month, 42 years, in a city like Austin, even with 1.5 million, I have thousands of conflicts of interest. So I always have to ask that question early on. Why? Because when does the attorney-client relationship formed? It doesn't require a contract. It doesn't require the exchange of money. It's formed when you let that client believe that you will keep his or her information secret. Once you do that and you let that client talk to you for 45 minutes, and only then you realize, oh gosh, our firm actually represents the real estate firm that this lady likes, you're conflicted out. So always check early. When I say ask good questions too, there's a meta-communication about asking people to repeat facts. When somebody says, yes, my father died in February of 2017, and we filed a will for probate in June of 18, it's always good to say, now, you told me that he died in February of 2017. Is that correct? By asking that question, the meta-communication is, this person's listening to me. This interviewer is listening to me, and they're depending on the truth of what I say. So I better be accurate in what I tell that person. And when you do that, half the time they'll say, well, I'm really not sure. But you wouldn't have known that. You would just go along your way, and then you find out a month later that, nope, that's not true. It wasn't true. So ask good questions. Key facts. Ask them to repeat key facts. Let's go on other things that we do. Interviews, good communication. What's the goal of any client interview? I want you to write these two words down. Reasonable expectations. The goal of any client interview is reasonable expectations, and that means what the firm can do, what other options exist to obtain the relief they want, and how am I going to be paying the fee? That's if you get good answers to all those questions and good explanations and you give them good information, they know the limitations. If somebody comes in and says, if let's say you're with a personal injury firm and they say, yes, I had a car accident and I have $2,000 worth of chiropractic, and they go, well, all right, what do you think I can do for you? And they say, I want $1 million. Well, that's not reasonable expectations. So we're going to get to that in this next slide. But you have to have, at the end of the interview, reasonable expectations. They know the limitations and the power of what your firm can do, how long it's going to talk, what other options exist. It might be, for example, I give this example to lawyers. Somebody comes in with a consumer complaint. They bought a piece of machinery for, $2,900. It turns out to be a dud. And you say, I might be able to get 90% of your money back with a couple of letters, but that last 10% will probably be a lawsuit. It's going to take at least 9 months, even if it's fast-tracked. Given that option, they might say, you know what, if you can just get me 90% of my money back, I'll just eat that other 10% and, move on with life. So give people options of what the relief could be. All right. Don't overlook those housekeeping items, like I said. Do I have any conflicts? Are there any previous lawyers? What are the client's motivations, right? Does the client who tells you, and I think I have it on a later slide, I don't need to sue. I'm doing it for the principal. That's a bad client. Why? Because they have already proven to you with that statement, I don't need to sue, but I'm doing it for the principal, that they have unreasonable expectations. And you might want to take that case, but make sure you understand that you will never make that client happy. Anyone who comes in with unreasonable expectations, you simply can't make them happy. Make sure their goals are reasonable. Make sure they have the right motivations. Don't get yourself into something. I don't know if this went to 2. Let's see. So here are the 2 critical questions you have to ask. After you listen all the way through, what do you think we, the firm, can do for you? And if they say, I want $1 million because I have $2,000 worth of chiropractic bills, that's not realistic. You either have to talk them down off that and make them understand that, look, in this type of case, because you are recovered basically, blah, 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 I can't imagine that we're going to get, and you haven't suffered a loss of a body part or something like that. We can't get you more than whatever the number is, $8,500. That's kind of the absolute outside limit. If you want to get a second opinion from someone, go get it. All right. And now the other thing that you have to ask them is if it's something that will have an opposing party. Ask them this question: What's the opposing party saying about you? All right, we get to be a mouse on the wall, and that opposing party is talking about you. By asking that question, you are prophylactically protecting them from any fear of telling you the truth. So they will finally tell you the truth. Well, they're going to say that I'm an alcoholic, that I've been through bankruptcy 3 times, that I've had 3 divorces. And, of course, none of that is important to my case. Of course it's important, but it's what they left out of the interview because maybe you're not the first law firm that they've interviewed. So they don't want to tell that bad stuff. But by asking that question, okay, what's that horrible opposing party saying about you, those bastards? And they'll tell you the truth. And all of a sudden you have to reassess, oh, my God. If that's true, maybe I don't want to take this case. All right. Then if you do, though, discuss the timeline, the cost, the alternatives that they're going to have to face. All right, let's go on. What if they suggest the firm's client, Mary, comes in and she has Paul and Jeff with him and said, well, Paul, Jeff, and I want to start a limited partnership to own real estate. Whoa, the interviewer and the attorney should stop and say, okay, who am I going to represent? Mary's been my client for 10 years. She's always going to be my client. But if I'm going to represent the entity, you all must understand that I can't have any secrets for any of the 3 of you who will all be equal members in this entity. So tell them who you're going to have to represent, or if there's a limitation, or who you can or can't represent, or the implications of representing all of them. And if the client is in a waivable conflict, of course, you get that in writing, and I have various letters for client waivers. And then the firm really needs to ask itself these questions. Before you take any case, you have to ask, does this firm have the skills to do that? Does the firm have the desire? Do we have the technology? Now let me stop right there, because the easy one is the last question. Is my client crazy? And that's, does your little voice warn you about the client's sanity or ability to pay? If so, really be careful about recommending that the firm get into that case. If you're like the third law firm for this client, that's a big red flag to whether or not you want to represent that person. The first two lawyers must have been hit by a comet before I'd agree to be the third lawyer on a case. But here's the technology question. I am so busy, I give about 80 speeches all over the country every year, and I've been trying cases for 41 years before I agreed to become this job. So I really can't take cases that are going to require a lot of e-discovery. I simply don't have the bandwidth anymore. So if somebody says, no, we want to see all the correspondence from this firm for the last 2 years, that we want to sue from the last 2 years, I'm not going to take that case. Go get a big firm who will take 30,000 emails and look through them, because I simply don't have time to take something that requires lots of technology. So, and then just be realistic about what your little voice is telling you. All right, and then what about this? So you've taken the firm, you've signed it up. Now, what about follow-up? Always reply to the client, the court, or opposing counsel as soon as possible. Think of that as a triumvirate, as a triangle. The three people you've got to correspond with are your client, most of all, because you have fiduciary duty, the opposing counsel, if there is one, and the court system, whether it's the court coordinator or responding to a judge or administrator's question or something like that. I always get, and I tell lawyers this all the time, I send newsy updates on Sunday afternoon. I have gotten in the habit in the last 20 years. I'll come in on Sunday, and in less than an hour, I'll write 15 2 or 3 sentence emails. Dear Jim, I know the interrogatories were due on July 15th, but they asked for an extension. It was their first extension, so I gave them until August 10th. So I just wanted you to know what's going on. I'm thinking about your case. Well, just let me know if you have any questions. Clients love those little newsy updates that simply show that you are keeping them up to date on what's going on. I sent about 3 of those just yesterday at 6 o'clock in the evening saying, hey, I haven't heard from you on my question on Monday. I'm just following up. If you're on vacation, don't worry about it, but just trying to make sure that you got my inquiry. And then, by the way, that was the 3rd time I sent it. And then finally, after the 3rd, yes, I got it. I'm sorry. I'm just busy. But just keeping abreast of everyone and give everybody the benefit of the doubt that maybe they're on vacation or they're ill or something. So always be polite in those. You never start one with, hey, you son of a gun, this is my 3rd time. What the hell is the matter with you? No, always say, I guess you're on vacation because I haven't heard from you, something like that. I always say do your share of the work. If the firm has promised to cooperate with another firm, or you're a family law firm and your firm has agreed to do that decree, get it out on time. I always say, because I came up through the ranks as a trial lawyer in the days before websites or email or even faxes when I were a new thing. Faxes only started 10 years into my practice. Didn't last very long either because of email. It lasted about 10 years. But, all of my business came from my own client saying, I love my lawyer. He does what he says he's going to do. He's reasonably priced, and other opposing counsel said he's very timely. If he's easy to deal with. He does what he says he's going to do on time. I said that is the secret of success: doing what you say you'll do on time. Do your share of the work. You all know, I don't know what your practices are out there, you all know that your people in your community, that when you see that they're on the other side of the case, you take a deep breath and you go, you know what, I'm going to do every document in this case because that other lawyer's firm is always going to have a series of tragedies befall them. They've lost at least 16 grandparents over there at that firm right at the time they were due to, give me a copy of the contract. So I don't ever want to refer people to lawyers who don't do things on a timely basis. We're just so backed up. You know what? So am I. Work late. And then you never withhold bad news or try to sugarcoat it. If a judge rules against you on a motion, first of all, make sure that that client knows that motion is pending, and then you never blame the judge. Say, well, we told you. I'm filing a big motion for summary judgment in a case, and one of the things that I did before even drafting it is I told the client, look, there is a cause of action that I don't think as a matter of law they can prevail on, but if we allow that to go to trial, it's going to probably generate 2,000 pages of discovery we're going to have to do. But so I think it's worth trying a partial motion for summary judgment saying they're not allowed to look at this particular entity or investigate it because it's irrelevant to the case. And I think we have a really strong shot at doing it. Now, it's going to cost me, $2,500 to draft a motion, and we're going to get then another $1,000 to get it heard. But so, that's what it's going to cost. Can't say exactly, but I think it's worth the $3,500 to do that. So the client has buy-in. They go, yeah, let's do that. See, they love that. I've told them ahead of time generally what it's going to cost. I don't think they're going to get mad at me if it runs over by $500, and if it runs over by more than that, I'll probably just eat it because I was the one that made the estimate. And then if that judge rules against us, well, the judge said that, blah, blah, blah. But you give accurate news. You don't ever blame the judge because everybody knows that's nonsense. And then keep after someone who's not responding to you. Now, let's talk about documenting our representation of a client. Always have a written contract, especially for new clients. With old clients, at least communicate by email what you'll be doing at their request. Dear Mr. Jones, yes, you've hired us now to do an additional, something real estate transaction, and we're going to do it on the same basis as we did the previous matter involving the Jones property. Fine, it just you've cited to them that you're going to do it on the same basis or something like that. I tell you that those little emails you send to your clients are absolutely the best inoculation for the entire firm against an ethics or grievance complaint. To point it out that I told you I was going to do this, you didn't respond, and so I went ahead and did that because that was part of our plan. So I said, well, you did that. You didn't tell. No, here's the email to you telling you that we were going to have to do that. Okay. So, and by the way, I have short form contracts, long form contracts. I have all kinds of things that people might be interested in. All right. And then finally, make sure. I assume you're doing it for money. Maybe some of you work out there for a pro bono agency and you're not doing it. And God bless you. I'm a member of the Pro Bono College myself. But how does that client plan to pay you? Don't start a case for someone who says, well, my brother in North Carolina is going to send the retainer next week, so go ahead and file a lawsuit. No. I'm waiting for that retainer to come in, for that prepaid fee retainer to hit my mailbox before I do it. And then ask yourself, look, if this client shows up, now here we're in Austin, we have what we call the Dellionaires, people that helped found Dell Computer. Now they're worth millions, and so they can walk around in flip-flops and T-shirts and, Bermuda shorts. But usually if a client comes in with flip-flops and Bermuda shorts, they're not trying to impress you very much and they probably don't have a lot of money. But don't get started on a case without a payment plan. And then I always say, one of the reasons that I agreed to do this CLE and create all these 30 courses, which I've done so far for LawPay, is because it made such a huge impression on my practice as a general practitioner representing real people for 40 years and being in a small firm for 26 of those years. I knew how important billing was and getting the money in the darn door. So I was one of the first signers on saying, okay, I guess I'll take credit cards, and this new LawPay company has gone, and it was like magic. Now, easily, more than half of my clients pay and almost instantaneously. Today, I'll be sending out bills only because I have to go to Chicago and I won't be here for the end of the month. And I can last month, the beginning of this month, the 1st of July, was billing day, and I remember sending out my bills electronically, and most people want them electronically at 11:30, and the first payment came in on one of them at 11:33. So it gives you such a sense of relief that you have such great cash flow because people like paying with a credit card. 65% of America pays with a credit card. That's all I'm going to say. If you're not using LawPay, you're missing it. All right. Always respond when the client communicates. Now remember this, and remember this concept. It's so crucial to the practice of law. People only remember what they want to remember. We see that in our politicians. We see that the way people just feel free to lie all the time. So when your client sends you that email saying, well, on February 1st, you said this whole thing would only take 60 days and it was only going to cost $1,500, and I'm now up to $5,000. Remember, you've written good notes when you interviewed that client, and that client told you as part of this transaction that he already had the deed from the oil and gas company, that he already had the apostille from the Secretary of State of North Dakota, that he already had the birth certificates and there had already been a personal representative appointed. So you can respond back. Back then, you told me these facts. And you do this politely. I'm not saying you yell or use capital letters, that you inform me. As it turned out, none of those facts were true, so I have had to spend that time collecting those things that I assumed by our interview you said were done. That protects the hell out of you. When you take good notes and you say, if you give, first of all, people only remember the lowest fee you quote. They do not remember the basis upon which you do that. So be very, 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 can I add one more, very careful before you quote a fee, a flat fee or a range. If you do that, follow it up in writing of what that would entail. That's so important to follow it up in writing with an email. Bob, as I know, I said that you told me you had these things, and if that's all true, I can probably just do this contract, blah, 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 and get you done $1,500. Now, when it turns out, but why are we up to 5? Well, because the 4 things you said you had, you didn't. So I had to do that. And when they misinterpret that, because people only remember what they want to remember. I have lots of stories about that, but remember that. Okay, fee agreement goal. Every time you draft a fee agreement or you send a bill, envision a court or a fee dispute committee reviewing that contract. Is the firm's contract clear? I mean, is it easy to read? It's not 12 pages long with gobbledygook in it. I have a short form 2-page contract that, is really very, very easy to do. Are the bills comprehensible and reasonable? Have you put in, and we're going to talk about dumb billing entries here in a little bit, but, are your bills, can somebody look at them and tell you what's gone on? Let's keep going here. Also, how's the client going to reimburse expenses? Are they going to do that monthly? Are they going to do that with a credit card? Are you going to require that the prepaid fee deposit be reimbursed? I always put a client's rights section in there that you have a right, because when I was the chair of the Texas Center for Legal Ethics, we had a woman who said, it was 2/3 were lawyers and 1/3 were non-lawyers, and of course they were very rich people appointed by Governor Perry at the time. And they said, I've hired a lot of lawyers, and they always tell me what I'm going to do, but they never really tell me what they're going to do for me. So I put in a client's right saying, you have the right to be treated with courtesy and respect of every member of our staff, and you have a right to have any communication returned by me or a member of the staff within 24, within 1 business day, and the privacy policy. If you don't have a privacy policy, you should, because most states are going to require it, and then also have a clause for your right as a firm to withdraw from the case if the client wants you to take a course of action which you disagree with. Even if it's a legal course of action, they want you to file all these additional claims which you don't believe are in the best interest of the client, you have a right to do that. And of course, venue for disputes should be your home county. Big picture. No practicing lawyer. Let's talk about fee disputes, because this always gets lawyers in trouble. No practicing lawyer will escape fee disputes. You can minimize them. We often share those faults by, we ignore those warning signs. The guy in flip-flops who, you have a $10,000 budget for him, and you go, oh, that'll be fine. And, of course, within a month, he can't pay you more than $500. And you're thinking, oh, boy, what a stupid guy I was for thinking about that. Spending too much at the outset. We see that a lot with younger lawyers, younger firms, where they get a $5,000 prepaid retainer and they decide they can spend all that just drafting the original petition. No, that original petition should cost you an hour, not $4,000 to draft. You don't get to spend more time because you got more money up front. You didn't budget correctly, and you outspent the projections without communicating why to the client with one of those emails saying, well, we're spending more because of these facts. And remember, the truth about clients is that a good client will always do their best to work something out with a firm. I had a woman who owed me $15,000 on a appeal. I let her pay that off at $500 a month, and she loves me for it. Never charged her any interest or anything, and I got my money. So I didn't miss a meal either by giving her that money to pay me, and she was a good person. If I had sued her for that fee, I would find out what a rotten person I am and what a terrible lawyer I was. So don't do that. And then ask yourself these questions. Would I be embarrassed to have the firm's fees reviewed if it went to court? What's the timing of the controversy with the client? How far are we through it? Are we almost done? Don't withdraw if you're almost done with the case and you just have a few hours left to go. I mean, you want to withdraw if you have a jury trial coming up and the client, and that is one of the exceptions in the disciplinary rule that you are allowed. It's usually under rule, I think it's 105, that you can say if they haven't held up their end. And most important, is it likely the client will ever pay you? I can't believe lawyers sue these clients with no money. They get a judgment against the client, and then it looks nice on the wall, but they never get any money. It should result in money. So, should I sue? The short answer is probably not. Never sue unless it's an existential threat to your firm. How badly does the firm need the money? If we can't go on, yeah, you go ahead and sue. But if you decide to sue, remember that counterclaims against the firm are compulsory. I always say the preferred option is to go to an ADR fee dispute committee. All right, let's see where we go. More reasons not to sue. You'll make more money. That's why I always say that. Forget this fee. I'm going to go make more money with new business. Overcharging a client breaches fiduciary duty, and you risk disgorgement of even the past fees under, this is the original case out of the Supreme Court of Texas in 1999. Every state that I know of has followed that, saying you can, if they raise fiduciary duty on overbilling, the court not only can make them you lose your fees you're suing for, but they can make you disgorge the old one. And remember, in most cases, even if you win, you won't get paid. All right, difficult clients. How many of you have looked at your phone and screamed just like this guy? I only do that. I'm down to only once a week doing it like that. But just because your client's emotional doesn't give you the right to be the same way. Never allow a letter to go out that you wouldn't want to see up on a PowerPoint presentation. Ooh, we used to, in the old days, we'd write these horrible letters and look at a rough draft and stick them in our desk drawer and then pull them out the next morning and realize that they were toxic. And, I'm so glad I didn't send them. Now we hit send, and we send that rotten thing in email. So you never threaten anyone, even passively. Passive threat is like, oh, yeah? Don't pay us, and you'll see what happens to you. That's a passive threat. You haven't named, but you're threatening them. And then always take that breath when you want to respond emotionally. Okay, handling billing complaints. Because we're fiduciaries, there's always a risk for suing for fees, and make sure you withdraw. When you do withdraw because the client hasn't paid you, look at your rules of civil procedure and look at your local rules and look at your disciplinary rule, those three things, to make sure you're doing it properly. Here's the 10 biggest mistakes, and I'm only, you'll be happy to know I'm only about halfway through this. Not establishing reasonable expectations, not resisting the client's invitation to guess or predicted outcomes. Don't be goaded into guessing how long it will take or how much it will cost. Not keeping the client reasonably informed, truthfully and aggressively to avoid mistakes and negative influences. Failing to respond to a client contact, which changes the narrative. You know, that one that says, you said this is going to be $1,500 back in February, and now I'm up to $5,000. Always respond to those. Stupid billing, and we're going to talk about stupid billing. That joy is coming up in a future slide here. Not using correct, intelligent descriptions in the billing, thus raising suspicions of overbilling. When you write a bill, it says, review file, 0.5 hours. That tells the court nothing. That tells the client even less. And not getting your bills out on time and using stupid stuff like that. The biggest firm criticisms they have against big firms is that they do the work in August, and I get a bill in the 1st of November. Well, hell, I don't remember what they did in August. But if they do the work in August and you get that bill out September 1st, that's when you're most likely to be paid because I remember it. Number 6, writing a letter that you wouldn't like to be seen by a grievance committee or an ethics committee. Telling a lie or treating anyone involved in the matter with contempt or disrespect. The judges talk about the lawyers that lie. You might have a perfect reputation for 15 years, but you misrepresent when some document was signed or how it was obtained and the judge finds out about it, you're screwed. The rest of your career is just gone. Making a threat, even passively, leading an opposing party to believe you're neutral or you're on their side. It's like when you come in and somebody's pro se and they go, well, I'm going to help you all fix this. That means you're that pro se party attorney too. If you say, I'm going to help you all fix this, you have to remember to say, yes, I know you do not have a lawyer. I will try to advise my client here on appropriate ways to resolve this with you in a manner that we're hopeful would be successful. Sending a communication to anyone that will burn a bridge. All right, let's talk about running your law office. How often does either a lawyer or administrator review the statements and checks? You know what? The dirty secret of the law firms is embezzlement is a real problem. I can't tell you the number of lawyers I've known for years, wonderful lawyers who have admitted to me, like, we got embezzled by one of the staff members or a lawyer, something like that. But it doesn't take 60 seconds a day to either look at the checkbook or look online and see. If you keep in touch every day, you'll immediately notice anything out of the ordinary and stop doing that. So that's all it takes. Financial control. Go online or look at that checkbook every single day. And then who's allowed to access to checking accounts? I know some of the big firms say, well, we're going to let these 3 people sign checks. That's generally a bad idea. You've got to have some controls on that. We don't have enough time to get into that. But most lawyers in small firms have the ability to sign those checks themselves because embezzlement indeed is a problem. All right. How does the firm bill? How often? What system do you use? I use time slips. Who reviews those bills before they leave the office? Somebody should. Do your bills include stupid stuff like review file, 0.6, telephone call, 0.5? Well, what did you talk about? Now you don't ever want to reveal confidential stuff in a bill because nowadays if a firm is seeking recovery of attorney's fees, the judge gets to look at the whole unredacted bill. In the old days, 20 years ago, we used to say, here are my attorney's fees, and all they looked like black lines out of the, some report. So they're all redacted. You can't do that anymore. The modern law says if you're going to seek attorney's fees, I want to see what the heck you did. So, you write it all and write a lot of narrative. To say review file 0.3 sounds expensive when you say review latest pleadings, check with court coordinator, you can telephone client to make sure he's aware of that, update the channel and make sure that and then charge 0.3. You look like a very reasonable law firm. Billing and collecting are the lifeblood of your firm. So let's do this. This is the famous Foonberg curve. Jay Foonberg out of California was the dean of office management, and I think Jay is probably 86 or 87 years old, wonderful old gentleman. But he had this Foonberg curve that said, look at this curve of how often you get paid. When you send that bill out at day 0, right after you're at the 90 to 100%. After 30 days, the client says, wow, that law firm sure is proud of their fee. After 60 days, the client says, that lawyer's crazy if he or she thinks I'm going to pay that much. And after 90 days, you're down to, I really didn't even need a lawyer for this legal service. So you get that bill out. It is absolutely, as I say in the next slide, a mortal sin for me not to have my bills out on the first business day of the month, and I've followed that tactic now for 28 years. Record that time diligently every day. We're going to talk about that in a second. Send bills out on time. Give the clients payment options nowadays that they can hit a return button and pay with a credit card. Incentivize them to pay and follow up on unpaid items. Strive for that 90% collection time. That means you record time daily. Every day. You forget the very next day. But here is the tip 1. Check your outgoing email. That will always kind of give you an idea of what you did the day before. Don't use shorthand that the client doesn't understand. You're not writing in emojis. You're writing in English. And never reveal confidences in your bill. Bad billing happens. I call it making the stapler a profit center, charging people for binding exhibits or office supplies. Look, because the client came in, they don't think you need to run to Office Depot to buy paper. Don't charge people for paper and this and that and binding. Your bill might be a great $2,100. What they'll get mad at, you charge $90 to bind exhibits? Or charging a surcharge for the use of credit cards. No. I bill by the hour. And if I know my client has a habit of paying, if I'm paying LawPay 1.95%, in other words, for every $1,000 I have to pay them $19.50, I'm going to work a tenth of an hour harder on that case, legitimately and legally harder. Know that I'll make that all up with another tenth of an hour's worth of work. Or charging excessively for legal research, bland description, file review, file update, or charging too much for faxes. Timely billing. It's a mortal sin not to get your bills out. Remember that client satisfaction curve. It declines steeply after 30 days. Give the clients the option of emailing them their bills. I guess in Austin, which we have lots of, technological corporations like this, everybody wants to get it. We don't have paper there. I'm just amazed. I'm the only one here in the office that still uses paper because this is all done digitally. But I'm old-fashioned, and a lot of things I like to have a paper file. And remember, use a payment link in your email. I'm about to show you that. So if you go to, and you can do this, you can go to my website, and I have a pay your bill button. And so what I do, see over here where it says the January invoice, as my bills go out automatically, I have this automatic stationery that says, attached, you'll find your regular monthly bill, and if you want to make a payment, you click on, mine actually says Pay Claude Now, and you click on that hyperlink that says make a payment or Pay Claude Now, and it comes right up to that wonderful page where they can put in their credit card, and then when they pay you, you get an email, they get an email. You just paid Claude $300. You just paid Claude $300, and I get one, said your client so-and-so just paid you. So look, that's actually my website. Look at the Office of Claude Duclos, and right on the right it says Pay Your Bill, and you can see what happens there. If you're not doing that, you're not serving your firm correctly. All right, let's quickly go into cybersecurity in the law firm. Crypto ransomware is estimated to cost users $325 million, and that was 4 years ago. Spear phishing attacks, target attacks used to acquire confidential information. String of law firms were breached in 2015-16 to obtain data on mergers and acquisition. And, of course, and now more than ever, you need to take steps, right? All right, so in-house mistakes, losing or disclosing passwords. I'll bet if you're in a big firm, you can probably walk around and turn over people's mouse pads, and at least half of them will have their password written underneath their mouse pad. After all, that's what I do. An in-house mischief, the insider threat is the most significant risk that companies face. That means nowadays you can get a 4 or 5 or 8 gigabyte flash drive and download just unbelievable amounts of documentation, more documentation than you could read in a lifetime, and walk out of it with a thumb drive that's, smaller than a matchbook. So you always have to watch out for insider. It's the most difficult to predict. So which means, how do you address that? Not everybody should have access to everything. One of the things we recommend is to document cyber assets in the firm. Look at this, make an IT asset inventory. Attorney laptop, a Lenovo Model T430, that's Chris, and Chris is the user of that. And so you just go through and you covers your networks, your computers and hardware, software and data, and then you can click off and see if everybody has up-to-date passwords on them, etc. Okay, wired Wi-Fi. We always say, jokingly, Wi-Fi routers are so easy to put in. Everybody has their 15-year-old do it. Don't. Have someone who knows how to configure a password do it. And don't connect it to who configured it. Do you have a guest Wi-Fi? Almost every router made in America or other places has multiple channels, so you can put guests on a different channel, and then make sure that you don't handle your private data by giving that password for your regular. What applications are you using? Critical to business. What's the application responsible for? In other words, who do you should be using this, and who should not be able to gain access to it? There's very little need for people like paralegals and even most attorneys to have access to the billing network if there's a number of attorneys. There are only 1 or 2 people who should have access to your billing network, and include data backups. The most important thing, always have a daily backup. And now, I remember those great big old, and at the time it was like 1 terabyte that you could attach to your computer and it would be backed up every day, and those were like $179. Well, now they're $49.95, and you can put it on your own computer, you can put it on a laptop, and you can back up your data every single day. All right, each asset. What's our goal? Securing, make them stronger. accessible only to people or systems, and you have a better passwords. The example include replacing weak passwords, updating and configuring and securing your connections, right, and ensuring systems are up to date. Let's start with the passwords. The easiest way to hack in are just to get your passwords. And remember, there are software that can run through 3 million passwords in, and they can load in information about you, where you live, with the name of your pets, your children, everything off, and they go through 3 million potential passwords in 2 minutes. So email and other accounts, common to websites. So let's look at this. Look at the bottom of this slide. There you go to this WWPC mag. A review of all the password managing programs and generators can be found on that. And in the next slide, I'll show you something. But a password manager, basically, see that number 1 above, that is a program that you put on your phone or your computer that manages all your passwords and makes them very well encrypted. So when you need that password to Delta Airlines, or you need that password to your local federal court's office, you can just put that in by putting in one master password that's very complex, and it will access all of your passwords. Now, I know a lot of you are probably like me, and I'm hoping that our IT computer engineer isn't listening to me, but I have a document on my computer, and it's not called passwords. It's some bland commutation, and the document itself is password protected, which you can easily do, saying here are all your passwords. And I honestly almost have to look at that thing every single day, because I have 3 solid pages of passwords for everyone that I do, but it's double protected. All right. Here are what we avoid for strengthening passwords: dictionary words, foreign words, slang or jargon, names associated with you. You should use 12 or more characters, upper and lower case. And here's the next thing I want you to see. Look at this. Password.kaspersky.com at the bottom of the page. This is Reggie Hirsch of Houston, who speaks a lot on security, cybersecurity. He recommends a long passphrase equal to what he said is, I love fresh sashimi tuna with a little soy and wasabi. That's 44 letters. That's almost impossible to break. And then he can adapt it by adding 4 or 5 more letters of whatever website he's going to do. So, I love fresh sashimi tuna with a little soy and wasabi email. That's my email password. I love fresh tuna with a little soy and Delta. That's for Delta Airlines. So, if you want to check the strength of your own password, do it at that HTTPS passwordkaspersky.com in. By the way, I think it's on the next slide, but see at the bottom where it says HTTPS on that password? Always look at the HTTP for the S. That means secure website. If you're just going to an HTTP, it is not a secure website. So don't don't go on there and share any information about your firm. Let's see. Okay. Fortify the Wi-Fi network. Generate a strong passphrase for the Wi-Fi. Select WPA2 personal, Wi-Fi protected access to. For most small practices, it could appear as WPA2 PSK or WPA2. Don't use WEP or WPA. It's got to be WPA2, WEP. Those are less secure networks. Strengthen your office system, printers, files to your private Wi-Fi network or LAN, not a guest Wi-Fi network. I'm sure that the slide deck will be available to you. I'm happy for it to be available to you, because I know we have so much that we've covered in this today, and I'm going to try to leave. Most Wi-Fi routers support 1 or more guestworks. One of the things, I'm showing you the WPA2, the authentication method, WPA2 personal. That's what your wireless router should be set at. Protect office system. Your office systems can be a treasure trove, and there are multiple routes in from network connectivity. So here, see these last 3 things. If you learn nothing else about cybersecurity, I want you to make sure you do these things. Make sure you go to My Computer and enable your automatic updates, enable your antivirus or anti-malware, and your firewall, those 3 things. You can go to, look at this control panel, all blah, 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 Windows, use the recommended settings, those 3 things. Your operating system's firewall to prevent external connections. Some software applications may require specific exceptions, etc. But you should do that. Train your staff. use a password manager. Don't ever disclose passwords, right? Never disclose confidential information over the phone, and immediately report any possible disclosure of confidential information. Now, part of training the staff, I always ask when I have a big, huge group of lawyers, how many of you could say your secretary or legal assistant or paralegal or other support person could put their hand under oath and say, I've been trained on privacy? That's so easy to do. It's a 5-minute training. It simply says, I understand what SPI, Secure Private Information, PHI, Private Health Information is, and I know that it doesn't leave the office unless the supervising attorney tells me that it leaves the office. And that's an effective privacy system. My 3 rules are: remember to treat the client like you're going to live next door to them the rest of your life. Nobody wants a bad neighbor, and if you treat your client like, you know what, they will remember that. I don't ever want a client to say that I treated them badly. So I try to remember, what would I treat Mr. Jones like if he were to live next door? What would I treat Miss Johnson like because I want her to think that I'm cared about her. Also, always tell the truth. There's going to be a lot less paperwork when you tell the truth, and you never sue a client. Civility. It's a process. It avoids confrontation, respect for all, good communication, reliance on the rule of law. Remember, the rule of law is our sacred trust that we're going to handle things in this country with rules. We're not going to take out guns and sabers and knives, and we're going to handle things with rules. And if the rules aren't good enough, we'll make better rules. All right, here's our summary that we're up to, and I'm going to try to leave a little time for questions. And I know a lot of you might want to get off earlier, but I'm going to stay on in case there are more questions. So communicate proactively with clients. Don't wait for an event. Don't take cases you shouldn't handle. Don't sue clients if you get burned. It's all part of doing business. Use ADR for fee disputes when available. All right. Oh, gosh, I hope this wouldn't show it. I keep this, what the survey says, actually on a little slip of paper right underneath my computer. They surveyed clients about what was most important. I'm sorry that for whatever reason, the way this presented, it was supposed to not present at the same time. Competence, communication, accessibility, accountability, and which they think was most important. And it's a huge survey, but they said the number one most important thing was collaboration. This is to clients. What the clients want most out of a law firm. Number one, collaboration. They understand my problem. They're going to help me. Accessibility. They return my phone calls and my emails. Number 3, communication. They tell me what's going on. Number 4, they take accountability. They don't blame the judge. The lawyer doesn't blame the legal assistant for what, my legal assistant, messed this up. No. The lawyer takes accountability for what goes on in the firm. That they show me respect and courtesy, and what came in dead last is competence. So that's really important. Now, I'm going to ask, I think I have a few minutes left to take any questions, and I'm happy to do that. So, Regina, if you want to let me know if you have some questions.
All right, so I just want to remind our attendees that if you have any questions, please chat those in the chat box right there. Make sure that your 2 is on all participants. And if you just want to send a private question to just Claude, send it to all panelists. And right now, no one has sent us a question at this very moment, but I'm sure you have some other things that you kind of want to talk about to us,
Sure.
Claude. We've got a few more minutes.
Okay, well, let me do this, folks. One of the things that you should make sure your firm has, and I'm glad to send these to you, is a good contract which addresses privacy, file destruction, and digital file maintenance. One of the things now that we can do with according to the ABA and all is that we can turn around the burden of making copies on the client. Remember, in the way we've been practicing law for 50 years, the client owns that file. So if you put it in and the client's paid his or her bill, they can come and say, give me my original file. And if you want to keep copies of it, you need to make those at your own expense. Well, what a digital file maintenance clause says is that you can say at the outset of the relationship, dear client, client, you understand that the law firm of Jones & Jones keeps your filed digitally. And so you agree that if you want copies, you will accept them in a digital format. And you are instructed, and it says discrete in a discrete file on your computer and password protected. And if you can't access, because the word accessibility is big in the rules, you can't access digital copies, we agree to cooperate with the copy service of your choice or to make you copies at our normal copy expense. You see, at the outset then, you can switch that whole thing about making copies so you can serve them digitally, and if they can't do it, you can charge them for whatever file copies that you make for them. The other thing that you can put in is a technology clause about, because what we're all worried about now is being hacked, right? So when we are hacked, we're worried the client's going to sue us. So with a technology clause, it basically says you and I, because it's perfectly fine, by the way, ethically, to send emails to clients for the time being and talk to them on the phone and send things over the phone. But you can put a clause that protects the firm by saying you understand that we use a commercial grade internet service provider, whether that's Google and you agree that if that service is hacked through no fault of the firm's. In other words, we're just one of those doctor's offices that gets hacked, that you are not going to hold me liable for the loss of any information because it's not my fault that my commercial grade provider got. So that's called a technology clause. That's something you can add to your thing. Also, now, for those of you who are in a practice who also do family law or litigation where your client's presence online, his social media, could be a problem. I have drafted, and I've sent around, and when I do speeches for the family lawyers, an exhibit, an additional addendum about social media. And basically it says that at the outset of your case, we will go through your social media. You may not destroy social media. You may not, because that will cause, us to be in trouble with the court. I say this very artistically, of course. But we will go through every one of your presents, and I will instruct you on what to take down. You will also not ever post. Here are the rules. You will never post online about this case, your lawyers, any other party, the judge, or anything. You will instruct every member of your family that they are not to post anything because, and I explain how dangerous it is to do that. And you will generally lay off unless you're a professional pollster that has to be online. Because, you have these things. There's just a myriad. I do a whole hour showing how stupid people are with their social media during litigation. They'll say, oh, my back is so terrible. Well, here I am at the disco with my 3 best friends, and we're having some really nice drinks. Guess what appears at trial? You're posting on Facebook about there you are drinking with your friends and looking like a drunk while your back is supposedly so hurt that you need a walker to walk around. They show people they show the rapper 50 Cent showing himself with piles of money. The problem was he was going through a bankruptcy, and he was probably surrounded by $100,000 in cash. That's not a very smart use of the time. So at any rate, there's all of these things that can get you in trouble. The other thing that I think you can do on there also, if your firm does freelancing, you probably need a freelance contract saying we will agree. If you're hiring someone as a contractor freelance lawyer, those made the same thing, or being hired as a freelance lawyer, you should probably have a copy of these freelance agreements that lay it out. Because remember, if, let's say, you're doing personal injury and you want to hire a freelance lawyer just merely to, do some motions for you, you want to make sure, if you're the freelance lawyer, that you get paid no matter what happens in that case. Otherwise, you could be saying, well, I'm now part of the trial team, and I'll live or die with what happens in court, and I'll be responsible if they commit malpractice. Make sure that the freelance lawyer always gets paid. Anyway, I have a million little tips like that, and I think I'm just about to run out of time here. So please write down. I don't know why my I thought they would have my email on there, but it's simply Claude at lawpay.com. Claude at lawpay. If you have any questions, you want to talk about anything, or you want a copy of any of the contracts I talked about, please let me know. I look forward to opportunities in the future to lecture you. I have lots of to give you some CLE tips, and I will now turn it back over to our host, Regina.
All right, this was great, and it shows in the comments everyone is chatting about how wonderful you did and how great this information was. And someone actually even referred to your webcast last Wednesday on trust accounts and how great that information was as well. So you did a fantastic job.
Well, thank you very much. We as I told you, that was a big subject. We had 973 lawyers registered to talk about IOLTA accounts, so that was very, very satisfying.
Wow, great, great. Well, all right. Well, this is Friday. We at the top of the hour, so we're going to go ahead and close out today's presentation. Thank you so much to all of our attendees. Thank you to LawPay, and absolutely thank you, Claude, for your great presentation. This actually concludes today's webcast. Thank you all for attending. The recording will be available at legalmarketplace.alanet.org. We will send all registrants an email tomorrow with this link, and please visit our event calendar to sign up for future webcast.
Okay, I guess I'm done.